Thank you. Can we go back to the necessary condition? Because I'm still not quite understanding it. First, I thought there was something in the legislative history that I may have read about Congress considering a necessary condition and taking it out. Does that sound familiar to you?
No.
No. Okay. Maybe I made that up.
That doesn't mean it's not there. The legislative history, though, is very helpful because it's got, and I highly recommend the Manel, Balganesh, Jane Ginsburg brief because it gives you all of the complete history and background, and they would read it a little beyond relation back where it's necessary to copy, but it basically is limited to these very core uses.
But what about commentary? That's what I'm worried about, right? That parody, I understand you would say it's necessary, and so that would fall into your fair use test. But something like the Campbell's soup can, where we've already established perhaps he could have used some other item to make the same kind of comment, would that not be necessary?
No, I think that Campbell soup fits in two places, and Justice Kennedy's concurrence in Campbell is really good on this point. What Justice Kennedy is saying is that the writer can always pick his target. You can always pick what book review you want to critique or what song you want to parody. So it's never, you have to say, well, you didn't necessarily have to pick on my song. So Warhol was entitled to comment on Campbell soup as a form of talking about consumerism and make whatever broader point he wanted to make about society. But the Campbell soup label, and not only is it a completely different purpose because one's an advertising logo that goes on a supermarket shelf to a work of art, but, and I think the government's brief says this, he can't have used a generic soup can. He had to use the Campbell soup logo. The same as if he had picked Cheerios. It would have been really weird to do, I guess back then they didn't have the giant Cheerios, but you got to use Cheerios to make your point about consumerism and brand loyalty.
Necessary.
Absolutely necessary.
Some branded
and
product.
What the government would say, and obviously the government can speak for herself, but they would say at least useful, and we're okay with that. We're actually okay with anything other than the new meaning or message test.
But the Second Circuit looked at this a certain way. And are you saying they did it wrong?
No, they did it absolutely correct because they were just rejecting the district court and saying, we're leaving open everything, but something that says Prince looked iconic versus Prince looked shy based on these interpretations of what one might reasonably think of Prince's, I don't know, mood or something, or personality. But I read the Second Circuit as way broad, saying you don't have to comment. I mean, I think they leave open all kinds of stuff like collages, like if you took a picture of Prince and made him into like Goldsmith's Prince and made him into a big butterfly, I think they would say that's completely fair use. So I think for your purposes, and which is what's driving all the, the amici being kind of very upset here, is just to reject a new meaning or message test where it's just a bare, unadorned new meaning or message test. It's not tied to any purpose other than I want to make some money off some art and I had some really cool idea here.